Thank you, Mr. Chairman. Mr. Smith, you've said several times in your deposition that you believe that the facts and the law, your interpretation of the law, would lead to a conviction of President Trump. Is that correct?
Yes.
And did you believe that same thing, that your interpretation of the law, your reading of the law, would have resulted in the conviction when you went after Virginia Governor Bob McDonnell back in 2014? Did you believe it at the time?
I did believe, and
ultimately you got a conviction in lower court, but that was overturned by the Supreme Court, correct?
Yes, the Supreme Court changed the law on what constituted an official act. And
Actually,
as a
that's
result,
incorrect.
that conviction was overturned.
That's incorrect. They applied the law, and they said in their ruling, our concern is not with tawdry tales of Ferraris, Rolexes, and ball gowns. It's instead with the broader legal implications of the government's boundless interpretation of the federal bribery statute. A more limited interpretation of the term official act leaves ample room for prosecuting corruption while comporting with the text of the statute and the precedent of this court. They accused you of using a boundless interpretation of the federal bribery statutes. Now, did you believe when you went after John Edwards that your interpretation of the facts and the law were correct and that you would convict John Edwards of corruption?
Yes.
But in fact, that case resulted in a jury deadlock on 5 charges and acquittal on another charge. Is that correct?
That is my recollection. That's correct.
Let's move on to the court's interpretation of your gag order requests. Mr. Smith, America was founded on the principle that the government doesn't silence political speech, in particular speech before it happens. You sought a prior restraint against President Trump without a single violation of pretrial release. In fact, there was no real-world harm that you could articulate justified giving the federal government the power to silence him as a presidential candidate, was there?
The court granted those motions and found that the prosecutor did not have to wait until someone was harmed to make such a motion.
Actually, the request was rejected when the case was actually, when you actually were not able to, it was restricted, correct? The gag order was restricted, correct?
Well, we filed for an order in the district court. The district court granted an order. President Trump appealed that order. The Court of Appeals absolutely agreed that there was a basis and that the threats to witnesses that came from the targeting by Donald Trump were real and that we had a duty to protect them. You are correct in that the Court of Appeals narrowed the order, so the order covered witnesses, court staff, the judge, and my staff. The difference was that it didn't cover me anymore, which I was fine with.
Did you have any evidence that President Trump's statements about the cases against him intimidated witnesses or prevented them from coming forward?
I had evidence that he said, if you come after me, I'm coming after you. He suggested a witness should be put to death. The courts found that those sort of statements not only deter witnesses who've come forward, they deter witnesses who have yet to come forward.
But you weren't able to identify a single witness who didn't come forward because they were intimidated by President Trump.
We had extremely thorough evidence that his statements were having an effect on the proceedings that is not permitted in any court of law in the United States.
Don't you think it's a pretty low bar to clear if you're trying to silence a candidate for president? I mean, if you can't identify a single witness who's intimidated, that maybe you should reconsider the gag order?
Both courts upheld the orders, and it is not incumbent on a prosecutor to wait until someone gets killed before they move for an order to protect the proceedings.
Did anyone on your team raise concerns that this expansive gag order you were seeking would infringe on President Trump's First Amendment rights?
My recollection is that we, of course, discussed First Amendment issues regarding this application because I and my staff respect the First Amendment, but the First Amendment does not allow one to make statements that interfere with the administration of justice in a judicial proceeding. My interpretation was supported and agreed upon by the district court and the Court of Appeals in terms of the phenomena of the statements being made, targeting individuals, causing threats to happen to them. I would also add, sir, that in the days after Donald Trump made some of these statements, the district court, in this case, received vile threats to the district court's life. In that environment, I felt a duty as a prosecutor to make that motion, and I make no apologies.
And the court stayed that motion on August 3rd, 2024. I yield back.
Gentleman yields back.